The core of the public trust principle is that government has an obligation to protect nature and its components as a life-sustaining ecological endowment that future generations have every right to inherit. The government then, as trustee, has firm fiduciary obligations. And yet, how many times have we seen the Forest Service approve a clear cut to benefit a local timber company, or BLM approve a mine to benefit a mining company? Every cyanide heap leach mine, every clear cut, every coal-fired plant, they've all been permitted and legalized by environmental statutes. There's something very, very wrong with statutory law. It fails to hold our government accountable. And not only that, this body of statutory law stands as the major barrier to legal innovation because Department of Justice attorneys and industry attorneys persistently use these statutes to defend their clients' actions, saying, our clients complied with all statutory obligations, and there's nothing outside of the statutes that warrants recognition. So back in 2005, I began developing a strategy that is known as atmospheric trust litigation. And it applied the public trust to characterize states and around this nation and governments around the world as co-trustees of the planet's atmosphere. And as co-trustees, they each have a duty to prevent substantial impairment of the climate system. And I suggested that citizens, particularly youth, could enforce this atmospheric trust duty domestically here in courts and worldwide. In 2010, the remarkable attorney Julia Olson formed a nonprofit group, Our Children's Trust. And the youth inspired a movement around their cases in every single state, drawing press from around the country and spreading the public trust logic very far and wide, voicing compelling moral authority as to why they deserve to inherit a planet capable of supporting their survival. Well, the first wave of cases met with a lot of dismissals, but there were also some real victories. Well, internationally, there have been many atmospheric trust cases, and many of those have won sweeping victories. And now in the United States, suddenly there is considerable momentum here as well. There was a case in Montana, a state case that went to trial and resulted in a sweeping victory for the plaintiffs, where the court found that the state of Montana had violated the constitutional rights of Montana youth. A case is set to go to Hawaii, to trial in Hawaii in 2024. And then the Juliana case has been revived. And there are many other cases here in this country and around the world that are teed up. It's very important to situate this principle correctly in the taxonomy of law. The trust obligation does not derive from the statutes. It runs much deeper than those. Courts have described the public trust as an inherent, inalienable right of the people that stems most basically from their social compact with government. The people give government power, not the reverse. This principle occupies such a central position in democracy that many courts have said it is an attribute of sovereignty itself, predating the Constitution. The best explanation I can give of this really comes from a Philippines case, this very famous, the Oposa versus Factorin public trust case, in which the Supreme Court of the Philippines said these basic rights need not even be written in the Constitution, for they are assumed to exist from the inception of humankind. That's important because we face mind-blowing urgency in the climate crisis, and we just don't have 50 years for a new principle to start seeding legal systems and developing from a blank slate. There is a need right now. And the job of earth lawyers is really now kind of like the job of rock climbers. We have to grab hold of all those firm anchors in the law and extend the logic of those anchors out. Our living generation stands at this incredible moment where our actions bear irrevocable consequences for the children and all future generations.